Okay, pause for a second. This is the arraignment. Think of it like the opening scene of a courtroom drama where the charges get laid out. Notice how quickly the judge rattles off the possible punishment. Up to 20 years. That's the legal system's way of reminding the defendant, hey, this isn't small potatoes.
You? Yes. Right here, please. Thank you. 23 CR 1647 is called. Carla Culver, who is present with Ms. Mantalini, your attorney and the state's attorney, and you are Carla Culver.
Yes,
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
yes, sir.
In summary, this indictment states that on or about September 29, 2023 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault causing serious bodily injury. And raise your right hand. Do you solemnly swear or affirm all statements that you make during these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Is that, do you understand what you're charged with here?
Yes, sir.
If convicted of this second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached for you to be pleading guilty, sentenced to whatever sentence shall not exceed a cap of 7 years. So you are looking at no less than 2 nor more than 7 years confinement in prison. You are looking at up to 7 years in prison, no less than 2 nor more than 7 years confinement in prison, and that can be suspended and you can be placed on probation for up to 10 years.
Okay.
And finally, can I place her on regular probation for this? Because that looks like a...
Here's where things get interesting. Probation isn't always an option. Why? Because the charge involves a deadly weapon. And in Texas, a car counts as a deadly weapon if it's used to hurt someone. Question for you. Should a vehicle always be treated the same as, say, a gun in these cases?
Deadly weapon was used by the... So I can't put her on regular
Between the serious
probation.
bodily injury and the
Yeah, deadly weapon, namely a vehicle, was used. So
only deferred.
only deferred is the only option for probation, which you could be placed on deferred or unadjudicated probation for up to 10 years in length. And is that your understanding of the options?
Yes, sir.
So you were looking then at whatever punishment shall not exceed a cap of 7 years in prison. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this offense charging you with the second-degree felony of aggravated assault? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. Among other things, the state you're mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses, and you were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true. So help you God. Is that so?
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Now, I think we need a pre-sentence report.
Yes, sir.
So what we're going to do is order that. We will return back, cooperate with the probation officer when they come talk to you. We will come back on
Be the first week of January.
in January. She'll figure that out here in a minute.
In January.
Everybody will have a chance to be heard, and then you will have a chance to be heard as well. And then the court will make my decision, and then you will move on with your life from there. Yeah. Did you say something?
Yes, sir. She also is asking the court to consider releasing her in this interim period on a personal recognizance bond. She's not able to post bond, and she does have family here in the courtroom and has a place to be during this time period. And if the judge were to release you on that sort of bond, would you or your family be sure that you get to probation to do the report?
Yes, ma'am.
And the interview that they need to do?
Yes, ma'am.
And back in court
Yes,
on the
ma'am.
date that you're told?
Yes, ma'am.
All right, well, what's her bond right now? You say it's too much. What is it?
I would thought you were asking your clerk. Well, how much is your bond?
20,000.
I knew it was low, seemed low. That's why she's still unable to make a $20,000 bond.
What's the state saying?
Based on the seriousness of the charge, Judge, I would object to a personal recognizance bond.
He's objecting to that.
Well,
The state's objecting to it. I'm reading, bond is based upon not only criminal history. I don't know of any criminal history she has. I don't. State may know of it.
She does. She's had a misdemeanor probation so far that I've seen that was revoked, Judge.
Okay, well, the terms and conditions of probation are similar to what bond conditions. If she has a history of failing to follow probation order conditions, then the bond conditions are essentially the same thing. But I'm looking at this probable cause affidavit, and this is and the indictment here, which
The bond debate. This is the classic courtroom tug of war. Defense asks for compassion. Prosecution argues danger. The twist? Her bond is only $20,000, which sounds low given the charge. But here's the catch. Bond isn't just about money. It's about trust. If you've already violated probation before, the judge isn't likely to gamble on you now.
states that you used a vehicle to crush someone's legs.
My understanding is the victim is still undergoing medical treatment.
and also, although
This serious bodily injury was called by the use of a vehicle, which is a deadly weapon in its very definition, the way the indictment is alleging, because it is a vehicle in its use, the way it was used, is capable of causing serious bodily injury or death. That's the way it's been indicted, serious bodily injury.
yes,
I'm disallowing your request at this time. I find that the bond is kind of low anyway. So that's the way it is. That's what it will be. But we're going to get this set for sentencing hearing here in a few weeks. Okay, that's all I can do. Thank you.
You need to get her thumbprint.
She needs a thumbprint over here. Aaron Hall.
Your Honor, everybody's been in the other holding cell.
Did you catch that? The indictment says she used a vehicle to crush someone's legs. That single line changes everything. Suddenly, this isn't just paperwork. It's a vivid, brutal picture of the alleged crime, and it explains why the judge just shut down the request for a bond reduction.
This morning.
Sean
And I just
Simon.
wanted to double check with Mr. Hobbs, Shan Simon also, as far as I know. He's, I believe doctors found him incompetent. We'll have that this morning.
Okay, I don't know that, but you're going to go find out for me.
I don't know, find out what.
All on Aaron Hall and Shan Simon. Did she trip over those legs? The leg thing?
I didn't see.
No, Rita.
Sit down. Sit down, please. Thank you, ma'am. Sit down, please. Thank you.
No, Shan Simon, doctor did already find him incompetent, so we'll do that this morning.
Yeah.
And then Mr. Hall, I believe we're gonna have to request a hearing in his case,
A what?
a hearing on his MTRP.
Okay. Okay. Let me
After
give me
talking
the
with him,
Aaron
unless
Hall,
he's changed his mind,
Shan
I
Simon.
haven't had a chance to re-talk to him again this morning because he's been on the other side of the building. But that's where we left it in our visit. And he's also gonna be requesting the court set a bond on his motion.
So she's a,
Sir,
hey, Kevin,
Yes, sir.
on Aaron Hall,
Sir.
it's placed on probation in June of this year.
Yes, sir.
And then on September, committing the offense of resisting arrest. In July, a month after he's put on probation, he's got cocaine in his system.
probably PCP at the time of the
Well,
arrest, Judge.
Is that what it's showing?
That's what the officer
Indications.
felt like.
Indications at the time of the
There's
resisting.
no,
arrest,
there's
Judge.
no test.
Okay, but nobody's got a scientific test to support that, right?
No, sir.
Okay, well, then curfew violation. Didn't complete the theft class. And is in arrears. Okay. Do you have Let me get, I need Joseph Matthews files, please. So what are we going to do on this? I see some dismissals. Is he pleading to one or two? It looks like there's 4 cases.
Yes, sir. He's pleading to tampering, which is the new offense. They're going to dismiss the murder. And those 2, the theft and I believe evading, those are motion for revokes. I believe they're filing some amended ones so we can run everything CC.
He's already pleaded true to that, huh? In these motions. It looks like on 334.
Right.
Yes, Your Honor.
But what I believe we discussed at the last hearing, but based upon him pleading true to this tampering, there was going to be an amended MTRP with this new offense, plead true to, and get that knocked out also.
Did I already make findings on those MTRPs?
You did, but
I just didn't. I made findings.
Yes, Your Honor.
Yes, sir.
Okay, but he's already entered pleas of true.
Correct. And I think the question was ultimately what happened with those. And I believe one, he had enough resolved, and I think the other one, he may have been continued on probation.
6 years is what we're doing.
Yes, sir.
And what about these evading and thefts? Those are state jails, right?
Right, and those are the, I believe there are going to be some amended MTRPs so that we can get those to run concurrent with what we have. I'm just not sure if that was.
We've already pleaded true to him. Why do we need to amend anything?
Judge, we
I
don't
don't
need
think,
to do that.
I'd rather, the less,
Yes, sir.
do we need to? He's already pleaded true. You can argue to me and then he'll just,
I'm fine with that, Judge.
then we'll just move forward without it. Where is
Mr. Matthews?
Joseph?
He's
Yeah.
right here, Judge.
Tommy, can we just take Mr. Joseph?
Well, good. I don't want to move her again, and I wouldn't want him stepping over her. 'Cause
I can't tell where she is. Her legs are there.
He stands from that position in the jury box, Judge.
Yeah, I don't care. I guess that's one way to do it. All right, go ahead. Stand up, Joseph, please. Let me go on this one. You call 23 CR 2020. Are you Joseph Matthews? Raise your right hand. Do you solemnly swear or affirm any statements you make today during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hands. Does the defendant, who is here with Mr. Samuel and the state's attorney, waive a formal reading of this indictment? Can we proceed in summary?
You may, Your Honor.
In summary, this indictment alleges that on or about November 22nd, 2020 in Jefferson County, Texas, it says, knowing that an offense had been committed, murder, you intentionally or knowingly concealed a firearm, namely a...
Now we switch cases. Joseph Matthews enters. His charge: tampering with evidence in a murder investigation. Translation: he didn't pull the trigger, but allegedly hid the gun. That's a third-degree felony. Here's the kicker. Even if you're not the killer, helping cover up can still land you years behind bars.
Handgun with intent to impair its availability as evidence in any subsequent investigation or official proceeding related to the offense of murder, I presume.
That's correct, Your Honor.
Which is a third-degree felony of tampering or fabricating physical evidence with intent to impair it. Do you understand what you were charged with here, sir? This is a third-degree felony if convicted, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. You would be pleading guilty, sentenced to 6 years in prison to run concurrently with other cases. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead to this indictment charging you with this third-degree felony of tampering or fabricating physical evidence? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true as state. So help you God. Is that so?
Okay.
State's Exhibit 1 is made a part of the record for all purposes. Is the pre-sentence report waived here?
Yes, Your Honor.
I'm going to follow this agreement. Anything else to add? If nothing else, I'm going to find you are pleading guilty here to this third-degree felony of tampering or fabricating physical evidence with intent to impair it from its availability as evidence in an investigation or official proceeding, as alleged in the indictment. You are pleading guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. Do you understand what has happened today in that case, sir?
Yes, sir.
All right, that is done on that.
And Judge, just want to make sure, as part of the time credit that he would get, it was going to be everything that he would have accrued from the original murder charge, which was noted on the plea papers. I just want to make sure that was clear.
Whatever the rules, the jail is competent to determine what those are. They're pretty good at evaluating. We can do our own
That's where he got those numbers.
analysis, but at the end of the day, I think the jail, the confining authority is the one who has the final charge on that.
And I think my clarification was just ensuring that any credit that he would have approved under the original murder charge.
It says
is
whatever he
attached.
is, well,
Correct.
it's whatever he's entitled to receive.
Yes, Your Honor.
And he's been in, no, that's all we can say.
And I understand that,
I
but-
can't gift him any time that he hadn't actually served under law.
And while I understand that, my concern was that with the new indictment of the tampering, that's what we were trying to avoid, was him having to do an entire another term on that. That was the basis of the agreement.
The murder is alleged in the indictment.
Yes, sir. Yes, sir. I'm making sure we're clear.
So I think that speaks,
Okay.
that pulls it in.
Yes, sir. That's all I want to verify.
But if it does, and if something happens where it doesn't, then I think it's fixable.
Yes, sir. Perfect.
But now we have these two first amended motions to revoke unadjudicated probation in 19-33415 and 33416. Does the defendant waive formal readings of these? And it actually, he's already entered.
Correct.
Is it true? But let's just seal the deal, as it were, and dot
Yes, sir.
the i's. We'll just go over it quickly.
Yes, sir.
Does he waive formal readings of these? Can we proceed in summary?
Yes, Your Honor.
And can we take these up together?
Yes, Your Honor.
In summary, sir, each of these motions, first amended motions to revoke unadjudicated probation, which were filed on January 11th, 21 in 33415 and January 4th of 21 in 33416, allege that you, Joseph Gerard Matthews, on March 23rd, 2020 in this court, were placed on deferred or unadjudicated probation for 10 years for evading detention with a motor vehicle in 33415 and theft in 33416. Both of these, each of these being state jail felonies. Is all of that true and correct? Allegation 1 states back in January of this year, you pleaded true to allegation 1 in each case, which states that you failed to report to the Jefferson County Probation Office on or about April 8th, 2020. And for the months of May and June of 2020 in violation of your probation order. Are those allegations true? You pleaded true already to those back in January, or are you reaffirming your pleas of true to those now? Also, you pleaded true to allegations 5, 6, 7, and 8 in each case that number 5, you failed to report to the Jefferson County Probation Office on or about December 1st of 2020. 6, you failed to work faithfully at suitable employment and provide verification of such in violation of your probation order. 7, in each case, that you failed to provide verification of performing community service hours as required. And finally, 8, you were at a location other than your residence at approximately 2:46 a.m. on or about November 22nd, 2020 in violation of your probation order. You pleaded true to those earlier, January 17th, 2023, or are you reaffirming pleas of true today? And do you understand a plea of true, a knowing and voluntary plea of true of 1 or more violations of probation are enough to grant the motions to revoke probation by a preponderance of the evidence or greater? Your probations can now be revoked. You can be found guilty and sentenced to no less than 180 days up to 2 years in the state jail for each case. Knowing that, do you insist on pleading true today? I find you pleading true voluntarily. you understand and appreciate the consequences of pleading true. All right. Is there an agreement on this?
Yes, Your Honor.
Which is what?
The 6 years TDC.
No. These are state jails. We've already done
He has plenty of credit, so
state jail.
a year
We can't get 6 years
There-
for the state jail.
from the state jail.
Okay.
I mean,
18 months.
I'm fine with that, Judge.
but I believe, Your Honor, they were both enhanced to a third degree on the MPRP.
Let's see. If they were, they're not showing because they weren't indicted that way. Let's see. There's the indictment. It's just one page with one indictment on each case. It doesn't have any priors. Let's see. This says evading arrest or detention, degree of offense, third degree felony. Don Dusler knew that. It says evading arrest or detention with the use of a vehicle. That's not. He pleaded guilty to a third degree felony, everybody. In 33415. You can see what this on this other one. This is a third degree felony on the theft as well. They're not state jails. They're third degree felonies. Y'all got to fix this. It's the way the order of deferred adjudication works. He wasn't state jail. These are third degree felonies.
Yes.
Let's fix that on the record. Is that true? Yeah. So he's looking at no less than 2 nor more than 10 years confinement in prison.
Yes, Your Honor.
So he gets 6 years on everything? Is that
Yes,
what we're
yes,
doing?
sir.
And here's the grand finale. 6 years across the board, running concurrently. Basically, Matthews stacks all his cases together like a bundle deal. Instead of serving multiple sentences one after the other, he'll serve them all at once. Smart defense strategy, but what do you think? Justice served? Or too light for someone tied to a murder case?
Yes.
Oh, okay. John,
Yes, Your Honor.
is that okay?
Yes.
All right. Then that's what we'll do because this agreement is inferred that you would get the same punishment on each cases to run concurrently. Is that your understanding?
Yes.
Y'all don't have a written agreement on this, right?
No, sir.
No.
Okay.
No,
So
sir.
I'm gonna. Do you feel like you need one in this case? Because I'm going to follow your recommendations of 6 years.
I'm fine with that, Judge.
Anything you want to add, sir? Is this what you understand is the plan, Mr. Matthews? And is this what you want me to do?
Yes, sir.
I'm going to do that then. I'm going to find, if nothing further, that you have pleaded true in each of these 2 cases of these first amended motions to revoke unadjudicated probation to allegations 1, 5, 6, 7, and 8 in each motion voluntarily, knowingly, intelligently. There's sufficient evidence. That's enough to support the first amended motions to revoke probation by a preponderance of the evidence or greater. I so find your deferred or unadjudicated probations are now revoked. In each of these cases, you earlier pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There was sufficient evidence from your original pleas of guilty from State's Exhibit 1 admitted in the plea hearings to support your guilty plea to find you guilty beyond a reasonable doubt. Now, I am finding you guilty based upon your violations of probation and your pleas of truth to these first amended motions to revoke probation. Your deferred or unadjudicated probations are hereby revoked. You are hereby found guilty in each of these third degree felonies, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years on each of these cases, which is what all the parties are requesting, as well as the defense, which falls in line with the new case agreement of 6 years in prison where cases would run concurrently. Is there anything else to add on each of these? If not, we are in recess on these cases.
Thank you.
Thank you.
Can you even give a thumbprint?